joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal, and I'm happy to be here today to talk to you about visa to green card options. And before we get started, just a few housekeeping items. This will be recorded, and we will add this to our YouTube channel, and we do encourage you to subscribe to our YouTube channel and click the subscribe button because we do have webinars occurring often, and when these webinars occur, we post them on YouTube, and then we do actually, you will actually get a notification. And the one thing to keep in mind in particular with this webinar is that we will talk about some non-immigrant visas and how to convert those to green cards. But each of these topics do have really separate webinars where we can go through them, or we do go through them in a fair amount of detail. So I do encourage you to do that. The other thing we will send you after the presentation is the link to the video. We'll send you the PowerPoint presentation that we have here. We'll also send you a link to set up a consultation. And we include a link to where you can download a bunch of guides that talk about each of these visa topics. So without any further ado, let me jump right into it. So before we get into the detail, I do want to talk a little bit about the green card system in the US. So the green card system in the US is very different from other countries in that the system is one where it's not based on a points-based system, but we're in other countries where you may get points for speaking the language, for education, for age, for work experience, for maybe how long you've been in the country. And then once you reach a certain number of points, then you're eligible to apply for permanent residency. But in the United States, that doesn't exist. Instead, there are just a list of green card categories, and if you're eligible for them, then you can apply. So very, very different from the way other countries work. And two of the biggest green card categories are family-based green cards or employment-based green cards. And when we're looking at family-based, they're broken down into immediate relative and preference categories. We're going to talk about those a little bit more in the next slide. And under employment-based, the green cards, we're talking about EB1 through EB5. The only one we're not going to talk about today is EB4, which is a religious-based green card, and our firm doesn't do those, but we are going to talk about each of the other green cards in a little bit of detail today. So first, let's talk about family-based green cards and immediate relatives. So the immediate relatives is a defined term, so it's not what we would normally think of as immediate relative. Like, for example, a sibling. A sibling actually falls into the preference-based category. But an immediate relative would be, for example, a U.S. citizen that is marrying someone that's going to be under the immediate relative category, or another immediate relative category would be a U.S. citizen over the age of 21 that is sponsoring their parents. Now, the benefit of the immediate relative category is that the category is always current. And what current means is that the green card is always available, because the way the other kind of interesting thing about the green card system is that for all of these categories, the government has set aside a certain number of visas that can be issued. And visa and green card they're used interchangeably, that can be issued every year. And once they hit that limit, people go on wait lists, and sometimes there are very, very long lines. So, for example, under the preference-based category of sibling, a U.S. citizen can sponsor the sibling for a green card, but there's around a 14-year wait for that. So it's quite a long time. Whereas if a U.S. citizen is sponsoring their spouse, or a U.S. citizen child over 21 is sponsoring their parent, there's no wait at all, because there's no numerical cap. So if you do fall into the immediate relative categories, there are certain benefits. And then preference-based categories, they're defined in the regulations. So there might be a U.S. citizen sponsoring their sibling. It might be a parent, a U.S. citizen that is sponsoring a child over 21. So there are a number of different categories. But the thing to keep in mind is that right now, all of those categories are delayed. So there aren't any, I believe, that are current at this moment. So it does mean that there is some wait associated with getting the green card. Now, in terms of the process for green cards, well, actually, let me talk a bit before I get to the process. So in terms of one way that people often get green cards in the United States is they get them through this family-based process. So a person on an E2 visa, for example, comes to the United States, they marry a U.S. citizen, and then they file for a green card. Or someone comes on a TN visa and they have a relative or a parent, for example, that is in the United States and they sponsor them for a visa. So family-based the family-based category is very common way that people actually get green cards in the United States. And you have to keep in mind that if you do have a U.S. citizen child, the child does have to be over 21 to be able to sponsor the parent for a green card. So now let's talk about process. So there are kind of two ways to get a green card in the United States. And the process, when you think of green cards, it's always going to be either a two-step process or a three-step process. So when it's a two-step process, or three-step process, there's always going to be an objective phase. So objective phase of, is the person eligible for the benefit? So in the case of a U.S. citizen marrying someone, the objective part is going to be, is the marriage a legitimate marriage? And you're going to be assessing that and filing a particular form. So in this case, that's going to be an I-130 form. Now, the second part of the process is either going to be adjusting status, so that's filing the paperwork in the United States if the person is in the United States, or doing consular processing if the person is outside the United States, or sometimes when they're inside the United States, there's going to be consular processing. No, that's typically the two-step process, and most green cards are two-step processes, but some are three, because some green cards have another step, because what's issued to you is a conditional green card. So if a U.S. citizen marries someone, they get a green card, but it's only for a couple of years. At the end of those 2 years, they have to file additional paperwork proving that the marriage is still legitimate, and that is to get the conditions removed. And that's similar under the EB-5 process where you get a conditional green card. So it's either going to be a two-step process or a three-step process. And that's going to be the case for both employment-based and family-based green cards. And the other great thing about I-485 petitions is that if you're able to file an I-485 petition, then you are also able to file for employment authorization and travel authorization. So you're going to be able to stay in the United States until your petition has been adjudicated, but you're also going to be able to file for employment authorization and travel authorization. So now let's look at the first employment-based category and see where we're at with this. So now, typically, this is an extraordinary ability category. So you're really trying to prove that the person has risen to the top of their profession. Now, in order to do this, you are going to look at the 8 criteria that are on the slide, and then you're going to make a determination as to whether or not the person has met those criteria. So with that, this particular moving to a green card, we see this people typically moving to a green card from an O1 visa because the criteria for O1 are very similar to the criteria for EB-1A. And as I said, you have to meet at least 3 of the criteria. So perhaps and really all of they're trying to get at showing that the person has risen to the top of their field. So one, for example, might be judging the work of others. You think of American Idol judges, they're people who have already, made it in terms of fame and risen to the top of their field. So they're selected as judges to judge other people's ability to sing and do other things like that. But there are also, lots of other ways that an individual can judge. Another example would be someone has a really high salary and they figure that if the person has a really high salary compared to their peers, then that means that they've risen to the top of their field as well. So once they've met 3 of those criteria, they may be eligible in this category. Even if they do meet 3, though, the government will do kind of an overall assessment to see whether or not they subjectively believe that the person has risen to the top of their field. Another good thing about this petition is that you are able to self-petition, so you don't need a sponsor or player for this, so that's good. And this can also be used for entrepreneurs, and we have done it for entrepreneurs. And this particular one's a 2-step process where you're filing an I-140 and then either an I-485 or consular processing. And this particular category is current for most countries. I think there's some that it's not. I think India and China it may not be current for, but it is current for most countries. So if you're filing the I-140, it means you can file the I-485 really at the same time. So. And just keep in mind, we just touched base on these categories, but for each of these, there is a separate webinar that we have, and we have ongoing and regular webinars, but we do encourage you to sign up for those to get more detail. So the second one we're going to talk about is national interest waiver. Now, this is based on a case. The case is called Dinosaur. And what you have to do here, there are three prongs or three requirements that you're trying to prove to get the particular visa benefit. The first is that the endeavor, like the first thing you do with the national interest waiver cases, make sure that or define what it is you're coming to the US to do, because this is not a profession-based green card. It's not you are doing this particular profession, and that means that you are eligible for national interest waiver. The first thing you do is kind of define what your proposed endeavor is, and you want to be as specific as possible, and you want to make sure that it's as grand as possible, so that you kind of meet the criteria of it being nationally important. It could be that you're doing something that's going to create jobs, to create an economic impact. It could be that you invented something. It could be that you're doing something with technology that is important, or the government feels is important. A lot of the time, expert letters can bolster kind of a national interest waiver case, so that's those can be important as well. The second prong is if the person's well positioned to advance the endeavor. So this one, they want to see track record, as well as look at your experience, look at are you going to be able to do what it is that you said? But keep in mind what you said that you would do in the first prong, the first criteria. So granted, it's good to make that as national or big as you can, but prong two can be the case where prong two requires you actually to show that you're able to do what it is that you said you would do in prong one. And then the final is a assessment that looks at whether or not the government should waive the labor certification. So we look at all the positive factors of this particular applicant to assess that. And again, there's a completely separate webinar, 45-minute or hour webinar on national interest waiver that we encourage you to sign up for, or to look at one of our old webinars on our YouTube channel. The other thing with EB2 category is you do have to look at the threshold considerations in order to apply under EB2, and this is going to apply for EB2 perm that we're going to talk about next. You do have to have either an advanced degree, so that's going to be a master's degree or higher, or a bachelor's degree plus 5 years of progressive work experience, or exceptional ability. So there's some other criteria. So let's say someone just had a high school degree. There's other ways that they can qualify under exceptional ability, and that's very different from extraordinary ability that I talked about earlier. Another big way, and just in terms of the types of visas that we see moving here, we see a lot of people on E2s moving from E2s to EB2 national interest waiver. But other categories as well. Someone might have extraordinary ability, an O1, and they might move to national interest waiver, or other categories as well, even H1B, someone could be working for an employer in the tech sector or something, and apply for a national interest waiver. So definitely a lot of E2s, but definitely a broad category. So EB2 perm and EB3 perm. So what this category is really is company is sponsoring you for a green card, and that's so a lot of people move to a green card this way. Could be a TN, it could be someone on an H1B. Usually the company wants some experience with you before they do this. It could be someone on an L1 visa. I kind of one that we don't talk about a lot in this presentation, or we don't have a separate slide for. But with an L1, you can sometimes EB1. There's another. We talked about EB1A, but there's another EB1 criteria, EB1C, which people sometimes move to a green card with as well. But this one really is, the government, the company sponsoring the person for the green card, and there's a process where they have to go through the Department of Labor first. It's called the PERM process, and the PERM process, you first have to define what the job is going to be paid, develop a minimum requirements job description, go through what I'll call is an artificial recruitment process to make sure that you can't find qualified U.S. workers, because that's what this whole process is about. It's an attestation or certification that you can't find qualified U.S. workers. The job requirements do have to be the minimum job requirements. So if you include things like foreign language requirements, it's going to be, it could make it very difficult. And this is with the Department of Labor. And once that's approved, then you can file the immigration process, which would be the I-140 and the I-485, depending on whether or not it's current as well. And of course, with all of these green cards, family members, spouse, and children under 21 can all join in that process. And the next green card we're going to talk about is EB-5. So we talked about EB-1, EB-2, EB-3. I mentioned already, we're not going to talk about EB-4, but EB-5, and this is an investment-based green card. So you're going to either invest 800,000 or 1,050,000 in a new commercial enterprise, and that's any business that started after 1990. The new regulations really focus on targeted employment. So in terms of how, when you decide whether you're doing 800 or 1,050,000, it's going to be whether or not the business is in a targeted employment area. So that's either a rural area or an area where the unemployment rate is 1.5 times the national average. When we're looking at this, we do want to make sure that the 800, like if it's 800,000 you're investing, you have to look at which investments can be included, because you can't, for example, include any administrative fees. One of the other things with this is that people often decide whether they're going to apply for a regional center or apply for direct investment, which is their own business. For clients that are kind of E2 clients, we see them often moving towards a direct business, direct investment. But for other clients that are either out of the United States or might be on a B visa or might be on a another type of visa like TN or H-1B, we see them often investing in regional centers, which is a much more passive form of investment. And when our clients that do E2, there are several differences with E2 and EB-5. Like for example, EB-5 is national specific, E2 is. The EB-5 has specific investment that's defined in terms of the specific number of jobs that have to be created, where E2 is a lot more general. The one thing with EB-5 is that source of funds is extremely complex. They do, there's no page limit with an EB-5, and they are expecting a significant amount of documentation with respect to where the money came from. And then the other big part of EB-5 is the job creation. So you are required to create 10 full-time jobs, and those jobs have to be for US citizens or green card holders. So that's something to keep in mind as well. And then this is going to be a 3-step process where the I-526 is filed. That's going to be the objective one, showing that you have invested the money and that you're able to create the employees. And then the I-485 and consular processing, depending on where you are. And for this one, if you're applying under the $800,000 rule, then you're lucky, for at least for a while, that the category is going to be current for all countries. And so if you're in the United States, you're going to be able to file the I-485 petition. And then the I-829 petition is something that you file 2 years after you have the green card. You're going to file the I-829 petition. So just so you have these on your radar, a couple of other, few other options, the diversity lottery. So that was, I think that just occurred in October, November. So that's something, basically they pick 50,000 or so green cards every year. So depending on which country you're from, you can apply for that. So that's something you should keep an eye out. They're humanitarian based in special circumstance green cards. Like if you are a victim of spousal abuse, that's one. If you help the police solve a crime, that's another. And then obviously we hope one day that we will see immigration reform. In terms of timing considerations, you always have to, when we're moving from a non-immigrant visa to a green card, we always have to keep in mind that we have to maintain our underlying status, and we have to kind of look at, well, okay, if we're on a TN and we're applying for a green card, we want to probably try to apply for the green card such that you don't have to renew the TN visa, So that's something that you always want to keep in mind, and make sure that you are actively managing your situation so that you don't run out of status. And a lot of the time we do have clients that do parallel green card strategies, like file multiple petitions, like maybe an EB-5 and an NIW at the same time. And really what we say here is planning is kind of key for these petitions. So perfect. And then that is really all of the prepared remarks that we have. And I'm just taking a look, and I don't see anybody has any questions. I'll give it a minute or two. And someone raised their hand. But if you do have questions, you can just add them to the chat function or the Q&A function, and then we will be able to answer those questions for you. But I will give it a minute or two, just so that people can add questions, because I did neglect at the beginning of the presentation to mention that people could do that. Okay, there we go. So we do have the question here. Going from E2 to, so I think maybe it's just finishing the question. So it's a question I think that has to do with moving from E2 to EB-5. So we have a lot of clients that move from E2 to EB5. And the key though is that even though you did E2 visa source of funds analysis, you really have to get an experienced lawyer to look at that, because the analysis usually will not be sufficient for the purposes of for the purposes of EB5. So that's because even though you may have met the requirement for E2, it's just a much more simplistic or simpler assessment. And we have, okay, EB5 is a direct business creating 10 jobs sufficient, is 800K or 102. So the 800K or 1,050,000, it depends on whether or not where the business is located. So in both cases, 10 jobs have to be created. If the business is located in a targeted employment area, then the investment amount is 800,000. If not, it's the 1,050,000. We have another question here. Is it possible to have an I-140 in process for an EB2 in the same file at TN? It is possible. I think that you wouldn't do that if you had the I-485 file, but it is possible. Keep in mind that when the I-140 is filed under EB2, it can either be filed as self-petition or it can be filed by the employer. If it's filed by the employer, then you're not even the petitioner, you're the beneficiary, and it's unlikely that even when you apply for a TN that they would be aware of it. And you just want to make sure you always include on your petition that you plan on doing consular processing, because getting a green card is not prohibited. What's prohibited is entering the United States and having the intent to adjust status. So that's they're kind of different issues. But yeah, we definitely have people who have done that. We have another question. As crypto investing booms in Bitcoin, if a significant gain was made in excess of 2 million on a 2K investment, is that okay for proof of funds, as only 2K was invested years ago? Yeah, it definitely is okay, but you have to show where you got the $2,000 from, and then show statements showing that the Bitcoin increased over time. So let's just say that, change the example slightly and say that it was a stock. And every month you get statements from the company. If that's available from whoever's the exchange or whatever, then it could work. But if it's not available, like, they're not just going to accept, well, I only invested 2,000 and it grew to 2 million, so just take my word for it. You definitely will have to provide statements showing that because the statements, the government wants to make sure to see there wasn't any more money invested, because if there was more money of your personal funds invested, then you have to provide source of funds information on that. So extremely complex in terms of doing that. So we have another question here. If one is looking for an E2 business and a TEA with future EB5 transition in mind, how can one determine which is eligible for TEA? So if you Google, there are TEA calculators out there. They're third-party calculators, but all they're really doing is they're going to the area and looking at the census tract and seeing what the unemployment rate is, right? So that's all they're doing. And sometimes it's a little more complicated than that, but not much. So you could either do it by using one of those calculators, or you can do it by looking up the government census tract and determining whether or not the unemployment rate is 1.5 times the national average. I'd say it's a little bit more complicated just because if let's say that the census tract said the unemployment rate was 7%, so that's obviously 1.5 times the national average. So you wouldn't have to really go any further, but there are instances where sometimes going further it works, because you can, like, if you have an adjacent tract, then you can utilize that in your actual calculation. So seeing you at future webinars. Thank you. Bye-bye.